said slow down, they said fall back, but the doubts hit the tank and it's all high octane gas. Let's go, yeah, we run it up clean. Funny thing about the hate is it fuels the machine. Let's go, all bark, no bite, no teeth, while they're stuck in the comments with 10 steps past belief. Eyes locked, no breaks, no pause. Every shot they take just reminds us who we are. We don't beg, we don't fold. If they're watching this mad, yeah, the plan's still gold. So talk it out, type it slow. Every hater in the crowd just helps the engine go. No fade out, no laying low. Fueled by the hate, still winning though, yeah. Yeah. Roll it back, run it up, save energy, let's go. Let's go.
Hey everybody, joining me for a very dark Wednesday. I have had a freaking migraine all day. I'm in a mood. I'm tired. And we have a lot to talk about because we're looking at one person, two cases, and we have a lot to get into. Firstly, as we all might be aware, the South Carolina Supreme Court threw out Alex Murdaugh's double unaliving conviction. Because of the court clerk at the time, Becky Hill, writing her book and jury tampering. In which case, Alex Murdaugh decided to sue her in federal court, looking to get his attorney's fees in approximately $600,000 for jury tampering. We have her response, her motion to dismiss, and her affirmative defenses. But first, we do have the hearing from last week in South Carolina, where they are going to set a date for a new trial with a new judge. So we are going to look in on that first, because that hearing is actually kind of, in my opinion, pivotal to her motion to dismiss. And a couple of things that Becky Hill states in her motion to dismiss are addressed unintentionally, not by name, but they're addressed in this hearing. So we are going to watch that first. Then we are going to get into the documents. I do have to go to work tonight, so you will see me we're not reading the 40 pages of documents word for word, because heaven forbid Becky Hill drives me up a fucking wall, because not love or hate Alex Murdaugh, think he's guilty as sin or a wrongfully convicted man. Becky Hill, according to the South Carolina Supreme Court, put her finger on the scales of justice. And she is the reason why people hate the court system. People like her, out to line their own pockets, greedy bitches. Need I say more? Yesterday, I did do a members only on this channel with some channel updates. I did put out a community post a little while ago with a scaled down version of the members only. The members only, we did get a little bit more personal and stuff. However, there will be some channel changes. If you do not subscribe to my other channel, Evidence Through Motion, also known as ETM, also known as Heather's channel, also known as my passion project, my career, the things I actually want to do with my life, the things I can look back on in 5 years and actually feel like I did something instead of just bitching on the internet. Please go subscribe to that channel. We are trying to get that channel monetized. It is up to 436 subscribers. I would really love it if y'all would join me over there. Really do. We're going to say hi to the chat, and then we're going to get straight into that hearing. I have it all queued up for us and ready to go. I was prepared. I was a little late due to a last-minute bathroom break. However, I got it all queued up. Did he get the 600K? We are not even there yet. But hey, Gail, good to see you. Mom, Dad in the chat. Papa Squid finally has a new bed. No, you have to stay down there. You have to stay down there, boo. So I will be putting the QR code and a link to my other channel in the chat frequently, because this channel will be not disappearing, but this channel is less important than it ever was, because I hate drama.
Hello.
And for some reason, this side of YouTube is all drama content, and it's annoying the ever-living F out of me.
Oh, it's just...
And I can't do it.
Mommy, it's Naha.
Yes, you have to get down if you're going to be talking the whole time.
Hello, Naha.
Okay. So, Duncan, Idaho, good to see you. Marta, good to see you.
Naha.
It's Grandpa, too.
No, it's Naha.
It's Grandpa, too.
It's Naha. It's Naha.
Ung Hung Hero, good to see you. Malin, good to see you. And thanks for you, those of you who joined me for the 10-minute live stream this morning on ETM that a certain toddler started. Yes, Angel, if you are going to be talking, you have to get down. Okay.
Mama.
So, yes, go subscribe to my ETM channel. Do it now. Do it now.
No.
Yeah, I know. Yeah. And on the other channel, I'm not afraid to drop the ban hammer if I tell you in a certain video that we are not talking about certain topics, and you bring up certain topics either in the chat or in the comment section. I will drop the ban hammer. You have to get down because you were not listening. So, hey, Volusia 1, how are you? Or Volusia 2 in this case. All right, so grab your drinks, your emotional support pitchforks, and we're going to see if we can sort through this South Carolina shithole. She's mad because I won't have her on my lap. It's because she's not listening. Karen, I am not stopping this channel. It just means that this channel is... So I did talk about it on the members only, and I did put out a thing, but this channel is a bunch of drama. Not so much the content that's talked, but a lot of behind the scenes. People are not as friendly as you think they are. People will act like they are your friend, and they are really not. And I'm really tired of trying to be friends with people who don't like me. So I'm not going to try anymore. But with that, I want to do something that I can look back on in 5 years and still be proud of. And this is not exactly... This channel drifted into a place that I'm not exactly proud of anymore. So that's why I started ETM, because that is a LLC I want to start. That is a business I want to start. I have a whole business plan that I actually was going to do a business meeting with a couple people this summer. However, due to the death of the DA in this area and some other 3D world things that happened, that got put on hold due to real life stuff. So with that being said, that's what I went to college for, because unlike some people would like to tell you, I did go to college. It might only be an associate's degree, but I did graduate from college, which means, yet again, Lips is a lying piece of shit, and I am sick of that whole bullshit. So, but I want to look back on something that I can be proud of in 5-10 years, and something that I feel like I put some good into the world. Also, I'm really sick of the people sharing screenshots. This person said this person said this. Oh, you don't like this, but no, I don't fucking like that person. I haven't liked that person in over a year, and no matter how hard people convince me that that person's a good person, I don't think that that person is a good person, and I don't like them, and that's okay. They don't like me either. It's fine. However, I'm done acting like shit is fine. I'm done acting like I'm friends with everybody when I'm really not. When I reach out to someone asking some questions and needing some friendly advice because I'm having a hard time with a friend who died and I get no response. When people say they're your friend and you reach out to them asking to help you with a logo and stuff for your new channel and they never respond to you. Are they really your friend? So I'm tired of acting like or trying to be friends with people that obviously don't want to be friends with me. With that being said, I am very proud of what I am building on the other channel because that is all myself. No one can say, oh, I helped you build that, or oh, I gave you content, or you stole this person's content. On this channel, I have had people in my comment section saying I stole my intro or copied my intro from Megan. Is this your first fucking day on the internet, princess? It's not. My intro has nothing to do with Megan. My petty chat rules have nothing to do with Megan. What I do on my channel has nothing to do with any other creator because I do what I want to do when I want to do it because I'm a 40-year-old woman and could give two flying fucks what other people do. And that's the kind of shit where I'm like, I am proud of what I've done because all that content over there, no one can accuse me of stealing anybody's content, of talking about something because somebody else did, of chasing clicks, chasing views, being involved in controversy. No, everything I've done over there is life experiences, personal experiences that I've had and content that I've created due to my degree and my 10 years of experience now. 12 years of experience since I graduated from college. So, yeah. I'm just sick of all the little shit and I'm not being nice anymore. I'm not dealing with this. Well, you copied like fuck I did. No. So we are going to get into this Alex Murdaugh stuff because this is not far from my house. And when this does go to trial, I am depending on when it actually does go to trial and if it stays on schedule, I might take a road trip because Colleton County is not that far from here. It's also not that far from Charleston. So my friends and I could do a couple day trips or a weekend trip and I could go to the courthouse. So this channel is transitioning back into doing what I want to do when I want to do it and that. However, next week, the focus will be a lot on this channel and Flash Fan will be joining me because Tyler Robinson's preliminary hearing is set for next week. Usually preliminary hearings are a half an hour to an hour. This is 4 or 5 days worth of a hearing. Oh, so you will see me want to bash my head into a wall quite a few times, but Flash Fan will be here to keep me level-headed. Before we get into it, Hung Hero, super chat. Thanks for the $2 super chat. Would have God get me banned over there. Not necessarily, because I know that you were coming at it from a good from an entertaining place. Volusia One is listening in. Hi, my friend. How are you? I hope you are doing well. Keep kicking ass with rehab and getting stronger, and hope to see your snarky self in the chat soon. Not that we don't love your family, but we want you to get back here as quickly as possible. So, All right, and M Spire, thank you for being a member for 17 months. Love you too. Love to you. I'm off to bed. Have a great night. And then Duncan Idaho, thanks for being a member for 21 months. Oh my goodness. I'm still waiting on my royalty checks. Yeah, when I get mine, when I get some checks, you'll get yours. Hey Malin, thanks for the 20 Swedish krona. FYI, I broke my toilet, so there we're sisters. How long ago was the Murdaugh trial? I want to say 2024. I watched it on Ricada's channel back in the day. I think it was 2024. Honestly, all the years are kind of running together, if you know what I mean. And then, holy crap, I've been here a long time. Roy, thanks for being a member for 21 months. And Roy was actually one of the first people to, I started a Give, Send, Go when I started this channel for a basic camera and refurbished microphone from Amazon. And he was the first person to contribute to that. So Roy is truly an OG on this channel. All right, so we are going to get into this hearing. And I have it queued up. It's 42 minutes in after they started their coverage. The judge finally comes in.
Please be seated. I see we have a full house. Good morning. For those of you who've never been to Lexington County, welcome to the Lexington County Courthouse.
And my phone disappeared, so I don't know where Lexington County is compared to Colleton County.
Give it right back to me. All right, we're here for a status conference. I'm going to get the clerk to call the case, please.
In the matter of State of South Carolina versus Richard Alexander Murdaugh, indictment number 2022 GS 15-00592 through 595.
Thank you.
Yeah, today
All
was
right,
payday.
Mr. Waters, how are you?
Good morning, Your Honor. Good to see you.
Good to see you. Now, let me ask you, I know some of your counsel at the table, but I don't know all of them. Can you please just let me know who the state's team is?
So I have David Fernandez, Assistant Deputy Attorney General David Fernandez. He's my number 2 in the state grand jury section. I have my boss, Mr. Don Zelenka.
I know.
We have John Metters as well.
I know Mr. Mathers.
See, Your Honor. You may see at various times. We have Assistant Attorney General Walt Whitmire, Senior Assistant Deputy Attorney General Melody Brown.
Right. Welcome. Let me, Mr. Harpootlian, can you tell me, I think I know just about everybody at your table, maybe not everybody, but can you introduce the defense?
We support, Your Honor. This is Jim Griffin.
Okay, Mr. Griffin.
Bill Barber.
Mr. Barber, good to have you.
A boy.
Okay. All right. I've made some notes on a status conference, and I'll let y'all talk in just a little bit. But I want to go over what I want to go over. Because I want to make...
Okay, I don't know if I'm going to like this judge from her rulings perspective or her personality. Well, but the way she handles her courtroom, I'm going to talk about what I want to talk about. A judge that shall not be pushed around, I thoroughly enjoy.
Make sure that all the discovery in this case is complete. And I made some notes, and let me tell y'all, I don't know anything about the first trial, so when you tell me something, please be complete when you tell me, because don't assume that I know, because I don't. I want to know about phone records. Do we have all the phone records, and are they complete? Text messages, cell phone extractions, and if there's any supplemental extractions, video recordings, whether there's ballistic firearms, are we complete in that? Fingerprints, toxicology. I think there was a blood splatter expert last time. I just want to know where we are with these discovery items. I'll let the state address that, please.
Yes, ma'am, Your Honor. So we have provided, and obviously provided well in advance of the first trial, a very extensive discovery. I'm not aware of anything in the items that you mentioned that have not been provided to the defense. And if anything, the defense has more than the state does, because a very heavy privilege review was done, for example, on Murdaugh's phone, formally named an attorney and that sort of thing. So.
And Unkong Hero, thanks for the $5 super chat. Which judge speaks slower, this one or the previous one? I'm not really sure, because I didn't stream the trial on my own channel and I haven't watched it in a while. I honestly don't remember, but I have this trial or this hearing at 1.25 speed. So if people start to talk like chipmunks, let me know and I will slow it down. No, this judge ain't no Southern Cal, is she? Well, y'all.
My understanding, complete extraction was provided to them, whereas the prosecution team, the investigative team, only received the privilege review, some kind of extraction that took place with this phone and that sort of thing. As always, we are constantly auditing and looking at everything, but I'm not aware of any discovery from the very extensive productions that have been made, not only from just the murder investigations, but also from the very extensive state investigations as well. So we have provided those. Obviously, I'm not aware of anything in the categories that you mentioned that have not been provided to the defense.
And not anything that needs to be reanalyzed or anything that the court would be waiting on?
At this time, no. Now, as you're aware, and we, of course, sent our responses to everyone last night, to the defense motions that were filed late last week. Came in the office Sunday to write those. One of those is their request for independent testing on DNA. We put in our motion, and I actually got an email from Mr. Brooklyn this morning that if they want to have their defense expert reach out to SLED as to specifically what capabilities they think they have and what they're supposed to do, happy to facilitate those conversations and discuss those with the defense, and then with Your Honor if necessary. Right now, that's kind of where we stand on that. And of course, any other issues that arise along those lines, we're very reasonable, and we're perfectly willing to discuss those with the defense. And if there's something that we can't agree on, obviously we'll raise those to the court.
Okay. All right, Mr. Harpootlian or Mr. Griffin?
Your Honor, I want to address everything but the DNA.
Right, I'll talk about the DNA later.
So we don't know what we don't know. And I'll give you an example. Let me hand this up to Your Honor and hand a copy to you. An interview done with a guy named Chapman and another officer who were folks that arrived on the scene to begin with, to process the scene, and were very involved in the forensics of processing the scene. And if you go to page 6, Chapman, who's in charge of the scene, says this. This is a television interview on March 13th, 10 days after the verdict in this case. He says, in response to the question, I believe he had some help in the aftermath. Or Rutland, yes, Captain Chapman. You know, the disposal of weapons, the moving around the vehicle. We heard so much about SLED and AG's office, they don't have anything. It's all circumstantial. So I pose this question to you. It was a clean crime scene, staged crime scene, clean crime scene. Would you expect to find more evidence or less? And that's what's kind of hard to get people to understand, is we didn't find a lot. But why we didn't find a lot? Because it was clean. I mean, it was manipulated. There's evidence removed from the scene. Now, this is 10 days after the trial. This is not what Chapman testified to. And if Chapman has evidence, there were other people at the scene, that he had assistance under their theory, or there were other people there, we need to have that furnished to us. And we have other witnesses that testified at trial who are saying something totally different, indicating there's evidence to believe that somebody else was at the scene, or there were other people at the scene. I mean, this guy's the chief guy in charge of the scene, along with Rutland, who processed it that night. We need, and we're in the process of doing this, to determine if they put those statements or the reports.
Yeah, and I will say, watching the first trial, I was not entirely sure that they proved it beyond a reasonable doubt. This lawyer, he's a really good lawyer, but every time I see him, all I see is my brain goes to his head shift forward and his spine and the look of his spine, and it makes me cringe. And it makes me want to think about my upright posture. So if you ever see me like all of a sudden pop up, it's because I saw somebody that made my OT brain correct my own posture. With that being said, he's a really good lawyer, and I don't think the state proved beyond a reasonable doubt that he did this. I have always been under the, not assumption, but under the guise that you can be a shitty human being and still not be an unaliver. You can be guilty of a whole lot of financial crimes and a whole lot of other shitty behavior and still not unalive your family. So I was not convinced beyond a reasonable doubt. There was that seed of like, but did he really in this? Plus, I will be honest, I really don't like the prosecutor in this case. He reminds me of Bubbles for some reason. Or what Bubbles tries to be. And I can't. He is accused of unaliving his wife and his youngest son. So he has 2 sons. He is accused of unaliving one of them. So could Murdaugh look like any more of an evil character in a movie? No. No. He's got the evil villain look down, and I don't think that's helping him.
So we don't know what we don't know. We don't know what we don't have. We need some period of time to try to process that. And Your Honor, I say this, and no emphasis on trying to, we're not alleging that the state has hidden anything from us. We do know there were people that came to see us that said they had important information. We have no ability to investigate cases. We don't have subpoenas. We don't have grand jury. We don't have search warrants. And 2 or 3 of those people we sent to SLED. Did they follow up? One had extraordinary evidence about a tie-in between Paul's murder and the murder of a young man named Stephen Smith. But we had no, I can't compel anybody to come anywhere. We sent that to SLED. Did they investigate? They investigated, and I must tell you, there are a lot of pieces of information out there that, and maybe they just stopped once they got the conviction, didn't do anything else, that is inconsistent with our desire to get a conviction, have the conviction held. So they didn't follow it up. Maybe it does need to be followed up. We're going to have to go back and look at all of that. We're going to have to determine whether or not additional material developed since the trial. And of course, all of us were shocked by the court's conduct in the trial. I know we were, I know the state was. But it's caused us to go back and look at, and we haven't done a thorough job of all the testimony and read it all, not in the sense of appeal, which we've done, but in the sense of, in criminal cases, we don't have depositions. We don't have them here. We have a transcript, but not every, I'm sure they're going to get rid of some of these witnesses. They're horrible first time around. We get additional witnesses. But most of the witnesses, we have their transcript, their deposition.
That's so much easier to read.
And read all of that, and we get a sense of how you like to do in a civil case. So I can't say that we've got it all. I can't say that we don't have it all. Again, I don't know what I don't know. But I think we will be diligent. And one of the other things we talked about is Alex Murdaugh's access to that information in a way that makes it convenient for him and doesn't inconvenience anybody else. We'll talk about that. That's another motion we'll talk about.
I'll get to your motions in just a little bit. What I really want to know is about phone records, text messages, cell phones, video recordings, toxicology, fingerprints. You have all that discovery.
We're not sure. But we need to review it as if we're getting ready. It's brand new. Okay. Just we looked at it 5 years ago, 4 years ago. Doesn't mean we know we have. And we'll be diligent in doing that. But certainly I would think it'll take us some period of time to review that. One of the points, reminding me, we did not have OnStar data on Mr. Murdaugh's vehicle until halfway through the trial. That is not the Attorney General's fault. That is DNC's fault for not furnishing it. We had to do that on the run. We want to go back and analyze that, have an expert analyze that even more. I do on the other side. The Attorney General got it at the same time we got it. No inference, anything improperly.
Okay.
So that's part of what we need to do. We need to hire additional experts based on some of the views we now have on some of the witnesses both the state and the defense have. And they need to examine those reports to determine whether we have it. So it's going to take a little bit of time, Judge. I can't tell you today we have everything, because we don't know.
Okay. Let me ask you, Mr. Waters, what about the OnStar data? Do you have all of that?
Yes, ma'am. So, Your Honor, we actually, SLED had sent 2 search warrants to GM well in advance of the trial, and we're told we ain't got it. And I think what happened was during the course of the trial, we actually had the FBI buy a Suburban and essentially reverse engineer the black box in the Suburban in order to provide us telemetry coverage, which is all provided to the defense. I think when that testimony came out during trial, somebody at GM was watching and they were like, uh-oh. And so in the middle of the trial, I get a phone call saying, about all that OnStar data, actually, we got a bunch of it. We immediately advised the judge, advised the defense, provided that to the usual form. They assisted and agreed to go forward because each hour curious about what had that done. So that was nothing to the fault of the state, and we immediately engaged in what we needed to do to ensure the defense had access to all that information. As to him saying, we don't know what we don't know, well, I know my applications are, and if I have knowledge of something that's disclosable, then it's been disclosed. And so to imply that there's something out there, I mean, we're always constantly auditing that and doing our obligations, but I take discovery obligations very, very seriously. We're going to work to remove that. As far as the musings, I haven't watched this TV interview. The musings of some captain about, whether the scene was clean. Well, there was evidence presented at trial that it was standing water on the concrete pad of the kennel, that the hose was not put back the way that it normally was coiled by the person who was in charge of taking care of the kennel. So he may have been talking about that. But ultimately, while Colleton responded initially, the scene actually was in charge of the process by SLED, and they've had access to all that information. So to sit here and imply, we don't know what we don't know, well, I recognize that, but I know that my obligation is to provide that information to the defense. And if I'm aware of it, it's been provided. And we have done that. We've had it well before the original trial, and we will continue to do that. And as he freely recognizes, the OnStar data came in late despite our best efforts, and was immediately disclosed to them. They had every opportunity to process that information, and then they agreed, you know what, let's continue on. So that's not anything, any sort of indication of a bad process or practice on both sides.
So the bottom line is they have everything that you have.
To my knowledge, yes, ma'am, and we were very careful about going through all that discussion.
And you don't know of anything else that needs to be analyzed at this time?
Well, again, we have that DNA.
The DNA, and I'm going to get to DNA in just a moment.
Of course, it was analyzed ahead of time. Now, what they're talking about is in addition, as I expressed in our motion, and Mr. Griffin has responded, I'm happy to facilitate discussions, and if there's some capability out there that's beyond the capability of SLED, and it has a reasonable chance of providing some sort of analysis, then we're happy to do that. Of course, as we put in our motion, ultimately, there's absolutely no evidence that Maggie Murdaugh was in a struggle with anyone, that she had any sort of defensive wounds, that she was scratched any sort of attacker. And we also know that it's very common with how sensitive touch DNA is. We're constantly shedding DNA and picking up DNA from others by shaking hands and doorknobs and all the rest of it. So, this is a bit of a red herring, but that doesn't mean that we are not willing to discuss with the defense anything that they want to do, and if reasonable, we're the first to do that. And if there's any needs to come back to this court, we'll do that as well.
Okay, thank you. Sure.
We know from testimony in the first trial that the chief SLED officer involved admitted he misrepresented things to the grand jury. Since the trial, the case was dismissed, in which he testified because the judge found he was hiding evidence and misrepresenting that. That's the chief officer. No other SLED. But it raises questions with us, not whether it's been withheld by the state, by the prosecution, but did he give them everything he had? Did he do what he did in the subsequent case after the trial, where he had evidence? And I think we've got to go through it and look and say, are there gaps here? Are we missing something? And for us, and look, we want to try this case as quickly as possible. But what we don't want to do is not be prepared based on what we now know happened at the first trial. And we'll have a motion probably next week that will expand on that a little bit. We didn't feel that we wanted such a motion to set.
Well, and I don't. I really wanted to go over and see where we were with discovery. I want to set a timeline. I want to set out some pre-trial.
So the littles that I had to pause it because this comment, beyond the capability of SLED, like honesty, there was so much wrong with SLED in this first trial that, like, I am not a defund the police person by any means, but it made me want to be an anarchist and just dismantle the whole fucking thing and start over. Like, get rid of it, start from scratch. Can we fire everybody and start over? Because whatever was happening at SLED during the time of this investigation was an embarrassment to the entire South. South Carolina, you made us all look bad. You made the rural South, and Colleton County is only like an hour and a half from here. Like, I could throw a stone at South Carolina from my house. It's not that far. Y'all made us all look bad. Like, the freaking, when this trial was, before this trial was going on, they were auctioning off all of the items and the personal items from the hunting lodge or the hunting property. I could have driven in less than 20 minutes to that auction. And it was actually kind of tempting to go. Creepy, but tempting. Y'all made us all look bad. And I was embarrassed. Like, I get secondhand embarrassment for people, which is one of the reasons that I hate drama content. Is I hate cringe. I hate watching people embarrass themselves. Sled, you embarrassed yourself. Hardcore embarrassed yourself. And it was part of the reason that I wasn't convinced that he was guilty. I don't personally think that he did it. However, I think he had a hand in it, and I think he knows who did it because of the people that he owed money to. So it's Sled is given some unbelievable power by state legislatures, zero accountability. And I'm slowly, you will see things change during the stream, like the background here. I am slowly learning how to do that with Restream. So you might see things change. I figured out how to change the text and the color to make it a lot more readable and easier to follow.
No.
Yeah.
No.
And this will be my background during the entire month of July because
No.
250, y'all. So,
No.
yeah, this was my the mentality I took through that whole trial was he's an absolute scumbag thief, but that doesn't necessarily make you a murderer. And Volusia 1, if you can see the screen, she will not take this off. She will not take this off. Is this your favorite?
No.
Is this your favorite?
No. It's me.
Give me. Is that your favorite?
No. I think that.
Oh, it's not your favorite?
It's that.
Yeah, it's pretty, huh?
No. I.
Yeah, support babies.
I.
Yes. You want Mama to take it off?
Yeah.
Okay, I'll take it off in just a minute. That's the first time she's wanted me to take it off in a week. Yeah. So.
No, I don't want it.
Okay, I'm gonna restart the stream. Okay.
No.
I'm 80% sure he didn't personally do it, but yeah, he knows more than he said. Yeah.
Pause is free. Pause.
That too.
Pause.
It is paused.
Hey, pause it is.
I'm pausing it, but I gotta restart it because that's why these people are here.
No.
Conferences, and I want to set a trial date. That's why we're here today. And I want to go over some of these motions. I think some of them are not substantive that I could go ahead and rule on those today and be done. And I will set up a pretrial. I'll give y'all some dates and hope you brought your calendars. And we'll set a pretrial. I don't know that one pretrial is going to do it for this case. We'll probably have several. And that's fine. The court's amenable to anything that y'all need. And happy to hear what you have. If you find something, Mr. Harpoolian, that you need to bring to the court's attention and you want to file a motion, I am more than happy to hear it. Okay? All right, so let me move on to my next notes. And we've kind of touched on it a little bit. Experts. Do you know how long? And the reason I'm just asking is because I do want to set a trial date. Believe it or not, overnight when I was assigned this case became the oldest case on my docket. And anybody who knows me knows that I will move an old case. And I intend to do that with this one. So I'm asking Mr. Waters, expert witnesses, do you know how long you need to get expert witnesses and talk to people and get everything that you need for the prosecution of this case?
See, and this is the thing. The state has already prosecuted this case. So y'all should be ready like tomorrow. So y'all should not be having to delay this any longer. I don't honestly think that they should have wasted that. And this is me just being fiscally conservative. The man is in prison for 35 years for federal crimes. He is not getting out anytime soon. He is not going to make it out of prison alive. He's not a spring chicken. The average age in the US for men is 70. He will well surpass that before he is able to get out of prison. He will most likely expire in prison. So for the state to waste the taxpayers' money and retry this case when he's already in prison, to me is a waste of money. But that's my personal opinion. Y'all can feel free to disagree with me. It is what it is, but I just felt like this was a giant ass waste of money. But thanks for helping me make money, I guess you could say. Yeah, because I'm a bitch about it the whole freaking time. And Melon, thanks for the 20 Swedish krona. Baby Squid's paycheck. Hey, it's officially her birthday month. So, yep, it's your birthday month. How old you gonna be? 4.
Whoa.
That's 5.
Why?
That's 4.
1, 2,
That's-
4.
She's still getting the coordination of the fingers down. And
Whoa.
and Jeff, thanks for the $50 Ko-fi. I appreciate you so very, very much.
Text
Like-
daddy. Text daddy.
You want to text your dad? Okay, text your dad. There you go. You can text your dad.
Okay.
So I just think this is a waste of taxpayer dollars to, one thumbs down. What do you mean 1 thumbs down?
Yes, ma'am. So the vast majority of our experts will be SLED. So I think that, we are ready, within reason, of course, to move this as expeditiously as possible. We do have another expert who testified from the FBI and things like that, but much of that is the same. And so as far as the state's position as to scheduling, and I know we've already sort of stated this publicly, that we were trying to do this before the end of the year, like towards the end of the year, we're ready to go. So I'm not aware on the state side of any expert issues that provide for additional delay.
All right, Mr. Harpootlian, how about for the defense?
I thought you were talking about my stream.
You know, we have 8 expert witnesses. All of them are new. All of them are just beginning to get the information they need. The DNA, we are told, may take up to 6 months. It is, unlike what's been represented by the state, critical. Griffin will address the specifics of that in just a moment. But to try this case this year, you guys talking about going to the death penalty 4 months ago or 3 months ago. Try it before the end of the year. It cannot be done for us to be adequately prepared. And we talked about the laptop. Without the laptop, we can't come back next year. If we have to go down there and take in the banking box at a time to read documents, almost 20,000 pages of documents. So we came up with a way.
Well, surely, Mr. Harpootlian, he reviewed those before his first trial, did he not?
5 years ago. I mean, it's just a judge. I can't remember a case I tried 3 months ago when the material was on that. I mean, it's ridiculous to require him, not with all due respect, to require him to have a memory of each document that he looked at almost 5 years ago. And by the way, our solution to that, contrary to Mr. Waterford's motion, is ironclad. There's no chance of it being distributed. We'll give him a laptop. It's encrypted. Since there's no attorney-client on it, corrections can look at it. SLED can look at it. Anybody can look at it. And let him look at it without us having to take hard copies of stuff down there and review it with him. You can't leave it with him under the court order. In other words, you just can't take him to discovery and leave it. There's a court order prohibiting that. And I'm sure the warden does not want boxes and boxes of stuff sitting in his. But if we have that, and he could be reviewing these documents and experts as we're reviewing them, I mean, let's not forget, he's a lawyer. Now, he's a disbarred lawyer, but he has probably more trial experience than many of the folks on either side of it. So
I like how he's a lawyer, a disbarred lawyer. I love his lawyer because for as competent as his lawyer is and as hard of a job as he has defending a complete scumbag, he still manages to maintain a sense of humor, which my sadistic mind can appreciate. I don't know. Call me crazy, but I appreciate the fact that he can still, he's a disbarred lawyer. Let's clarify that. But he's a lawyer. It's just like, oh wait. Hey, Harpootlian just managed to say just because you are a disbarred lawyer does not mean you don't have a legal education. Take note. Whatever your name is, Luthman. Take note that you can't say that you don't have a legal education even though you're a disbarred lawyer. Just FYI.
he understands what he's looking at much better than any client I've ever had. So I think it's important if you're going to try to expedite this for him to have, and you talk about the laptop separately, but that's going to be a condition. It's going to take us at least 6 months to get these folks retained, have them look at the adequate material, look at the state's testimony the first time around, and of course if they have a change in who they're using or taking a different approach, we need to know that as soon as possible. I would point out that they were giving us discovery in the last case after the first week of trial, in the second week of trial. So we can't have that happen again. They say they've got it all. We can assume we have it all unless they want to supplement it. They supplement it sooner rather than later. That allows us to that. I mean, I think what we probably ought to try to do is figure out a trial date and then back up from that. What we're comfortable with is late spring, early summer next year.
Okay.
We can live with that. Given, if we have to go down there, one of us has to go down there 5 days a week. You need to be incarcerated on now, so there's 2.5 hours in here. It's a half an hour to get in. So before you even see it, it's 3 hours. And then you only have 3 hours with them, and then it's a 3-hour trip back. That's why the laptop is so important.
Okay. Ms. Griffin, anything you'd like to add as to experts?
I have been in contact with the DNA lab in Houston. I can talk more about that. But when I mentioned that, they were asked, how soon do you need it? And I said, well, hopefully we're looking at a spring, early summer trial date. And the answer was, well, we need to put a rush on it. And I can talk more about the lab if Your Honor wants to hear it. I mean, they are.
I'll get to the DNA in just a minute, and then we'll go forward on that. All right, let me talk about this computer at the Department of Corrections. I did receive your response, Mr. Waters, yesterday at 5. Did you get the opportunity to look at that, Mr. Harpootlian? I mean, basically, I just made myself some notes. You were concerned about the state grand jury material and talked about a protective order and some other issues. I agree about there are some sensitive issues. The state grand jury material is protected and should be protected. And then you mentioned an order that Judge Newman had. I kind of think, Mr. Waters, that when this case was reversed, that order goes out the window and we might need a new order for this case. It's my understanding that the order stated that the grand jury material is secret. And I mean, that's pretty straightforward. And I know that you would like to prohibit the digital dissemination of the state grand jury material, that there's no photocopying, scanning. I breezed through this. You don't want any digital copies. And all of this, while it doesn't prohibit the defendant from reviewing the case materials, you want the attorneys to make sure that they keep in their possession the state grand jury material. Is there any objection to that, Mr. Harpootlian?
Yeah. Your Honor, the issue of that is what is the state grand jury material? I think, if we can designate what that is. It's beyond grand jury testimony, which is, there's very little of that in the discovery. I think they've gotten things through grand jury subpoenas that have been produced, underlying records and whatnot. And so, is that really sensitive grand jury material? And some of us introducing evidence at the trial. I'm sure of that. But so no question about grand jury testimony. We have no issues with that. But it's just hard to say what exactly are grand jury materials when a lot of subpoenaed documents and information have been produced.
And Your Honor, if the issue is dissemination, I mean, he has a right to read.
Oh, absolutely. I said that. It does not prohibit him from reading it.
Issue is dissemination. I mean, we're just basically talking about the big Kindle. You can read on it. You can't send emails. It's not connected digitally or cell or Wi-Fi to anybody. It can be mailed. I want to say this: the Department of Corrections has been extraordinarily professional in dealing with us, giving us access to that. But no complaints with them whatsoever. But what we'd like is that laptop with the warden and corrections have total access to it. It can be inspected by SLED to make sure it can't transmit an image, a message, and be used in any way. There is no Wi-Fi at this particular institution, so it has to be by self-service. I mean, these are not difficult technical issues. And if they're concerned about grand jury testimony, we have to take that out. That's a local plan of what we want him to look at. And we can certainly do that separately with hard copies. We have to go down there and do that.
What's weird about that is they're so concerned with it being able to transmit. Do you know how many freaking things I see with like prisoners and cell phones and like prisoners putting shit on the internet and transmitting video? Like, why are they so concerned about it? I have priorities. Like, you're so concerned about him. What about the thousands of other inmates that are on the internet every day and that have access to tablets and emails? And it's the priorities of shit. I just cannot figure out why. And this is partially because I'm not a lawyer and I understand there's things I don't know. However, you're so concerned about one person, but not yeah, to Sarah Boone, I need a laptop. It kind of does remind me of that, though. Not gonna lie.
Let me tell you. Well, Mr. Waters, let me hear from you first.
Yes, ma'am. So we really, as far as the protective order, we really have two things. There was the state grand jury investigation, and ultimately there was the standard protective order for that. He's pled guilty to all those offenses. There's nothing reversed about that. But necessarily, as that state grand jury investigation was going, things came up that were ultimately relevant to the murder. So it's much bigger than they say. I don't have the number in front of me, Your Honor, but it was at least 20 witnesses, multiple subpoenas, and so all of this was in the dynamic. And as well as Judge Newman issued a second, in my recollection, protective order as it related to just sort of the murder evidence as well. So they're two separate things, but they all relate together. So all of this evidence is sensitive. On top of that, the murder evidence is in fact very, very sensitive. And frankly, we've been trying our best to protect it from improper dissemination because it's worth a lot of money. Now, one thing SCDC is adamantly opposed to is having an inmate have a laptop. They are absolutely 100% opposed to that. And I have to remind you that this is an individual who already had his tablet privileges taken away from misuse of that. This is an individual who was caught receiving contraband that was passed from a family member through the defense of and so this is not a guy who was, this is also a guy who's been convicted of over a decade of fraud. Now, they say that these things can be locked down and can be made to the state and I understand these issues very well. As the state grand jury made a point to partner with SCDC to fight the problem of fraud and corruption emanating from there, and it's done with the use of devices. This is a very severe security issue, and no matter what protections.
The Attorney General's office of the state of South Carolina has a really like pot meet kettle when you're trying to talk about fraud and corruption. Before you try to talk about anybody else, you might want to clean your own damn house. Just saying.
Put into place there's always ways around this. SCDC has experience with that. So the fact remains is he's an inmate. And SCDC adamantly opposed to there being some laptop that he has access to. Includes this idea that SLED is going to be able to review, attorney communications and work product on that. I don't understand how that's going to happen. Now, SCDC is happy to accommodate the defense and to any meetings they have. And no one says that the defense can't bring down digital evidence to review with them while it's under their supervision and then take it with them when they leave. That is absolutely the way it should be, that ultimately this information, whether state grand jury or not, is too sensitive to have an inmate, despite what protections put in place, have a laptop. Because Frankly, the reality is that inmates are constantly and successfully violating whatever protection there is. Despite everyone's best efforts, you're doing a great job. It's just a nature of the business.
Okay. Sure.
I had a serious email, and I don't see the Department of Corrections here today. I had an email chain with the warden at a particular institution, and he doesn't raise those again. He just, and we bring another laptop with internet cellular or Wi-Fi capabilities. So, and that's what this says. So, and with all due respect to the Department of Corrections, if we don't get the ability, I mean, Mr. Griffin and I, or Mr. Barlow, or Ms. Fox have to go down there, 3 hours down, sit with him for 3 hours, 3 hours back. We're talking about at least the end of next year, if not the beginning of the following year, to get this support. We can't be working on experts, and we can't be interviewing witnesses while we're tied to sitting there and babysitting him while he's reading a laptop that doesn't have any capability to communicate or talk. And we'll be happy to have SWED inspect it. We'll be happy to have the Department of Corrections inspect it. But, the idea, we bring laptops in. We were given, as you can see, permission to bring laptops in. Laptops are brought in all the time. The question is, can he keep, not he, but can the warden keep it, or some office at the institution keep it, and give it to him when he needs it? And Your Honor, I gotta say, the idea of bringing him in here chained up, the idea of not letting him have access to a laptop, the idea of opposing everything we're trying to do to expedite this process. I understand it's Mr. Waters' job to legally prejudice the defendant, but this is beyond the table. This is beyond the table. I'd ask you to remind Mr. Waters that he has an ethical duty to see that justice is done, not to get a conviction. Thank you.
Mr. Harper,
I don't.
And that,
Okay, we're not going to go there. But
and I have no intent to prejudice anyone. Prejudice suggests a decision on the improper basis.
and the court doesn't take it that way, Mr. Waters.
Thank you, Your Honor.
All right, let me tell both of you. I took the liberty of calling the warden and talking to him about the laptop situation. And because I too used to practice law, I remember terabytes of discovery that I had to carry to my clients to go see. And I know that it can be cumbersome, and I would imagine the discovery in this case is a lot. How many pages do we have, Mr. Waters?
It's very simple. It's a half terabyte.
Half of a terabyte, okay. I talked to the warden. He will not allow a laptop, and for safety reasons. He said he would, quote, make available a conference room. Counsel may bring their computer. They could have a law clerk come, or the attorneys could come themselves. They could look at it. He could review his discovery. They could bring their own laptop. However, somebody must be with him. His concern was having a laptop in his cell. No other inmate has a laptop in their cell. They do have access to an iPad that has Westlaw on it. Now, I just have to be honest with you. I didn't even think about asking him if you could download any discovery on that iPad. I don't know if that's available, but I certainly will call and check and see if that's acceptable to him. If that's the case, I'm going to have Mr. Waters draw me up a proposed order on the state grand jury material. I haven't looked at Judge Newman's yet, but I will. Please run that proposed order by Mr. Harpelian and Mr. Griffin. I will check on the downloading on an iPad, but I'm not going to allow him to have a laptop computer in his cell. It's for safety reasons. That's out of my control. I think it's not only for the safety of the others at the institution, but probably, Mr. Murdaugh, for your own safety. Okay.
We're not proposing he have it in his cell. We're proposing that the warden have it and give it to him to go to a conference room as he would with us, to look at it there. Does that make a difference?
Well, I'll ask him. But when I read your email here, this seems like he could go to his cell. He could keep it in his cell. I know good and well that the warden is not going to allow that. I talked to him personally. Okay. We'll follow up on that in our next pretrial. Or if I can, I'll probably let you know before pretrial. But if he says no and it's for security reasons, then the answer is no. I'm not going to allow it. Do you understand? Mr. Harpelian? Mr. Waters?
Law clerk or other person, paralegal
he'd let a paralegal go. All he wants is the name of the person, and you're more than happy. And he said he's not going to limit you to 3 hours. They can stay 8 hours if they want. He will make a conference room available so he could see the material. It does not have to be a lawyer. Okay, that.
I spoke with the director of legal counsel this morning, and they expressed the same thing. We're here to facilitate his defense doing that.
Right.
Ridiculous.
You know, I want him to have all his discovery. He's entitled to all of it. You know, it's safety concerns. It's
That is voice boosted.
if you can have a law clerk or a paralegal go down, then you're satisfied, Mr. Harpootlian. That'll help you out.
Automatically, it's not limited to 3 hours. It makes that 2.5 hour trip down, 2.5 hour back worthwhile.
Okay. Well, then I will verify that and send y'all an email tomorrow on that. That's okay. All right. Perfect.
Thank you, Your Honor.
All right.
Y'all know that court
Now, let
audio
me go
sucks.
through.
They don't like talking into microphones. They don't like the fact that they're being recorded. Nobody likes the fact that there's cameras and we like it. The average person likes it. I'm pretty sure the people being recorded do not like the fact that they know that there's a camera watching them. So they don't like to project their voice. They do not like to use the microphones. They're really bad at it. And then courtroom audio visual setups just suck. It's like lawyers and math. They just don't get along. Just, you know. It's like
I had a
doctors and
motion
lawyers.
filed for the defense, and I just want to put this on the record. The defense wanted the defendant to be unshackled in the courtroom. I received a response from the state. They objected. Then I had a response from Mr. Harpootlian where he withdrew that motion. That still stands, Mr. Harpootlian?
Yes, Your Honor, although we may renew the motion, our reason for this is jurors, potential jurors are watching this right now. It's going to be, wherever this goes, it's going to be difficult to get a jury. And to the extent that parading him around in a jumpsuit shackled like an animal impacts their view, it's going to make it more difficult for us to get a jury. Now, again, Mr. Walter's argument is specious. He's not dangerous. He's only convicted of stealing money. Now, Judge Newman let him come to the courtroom in street clothes and unshackled. I know Mr. Waters feels compelled to get every advantage he can, but this is one that I think this is our ability to get a jury. So I would ask that he be allowed to come in the courtroom unshackled in, I will call them street clothes. Now,
So are you renewing your motion now? Just want to make sure.
what I wanted you to see today is this. I mean, chained around the waist, chained to the hands, chained on the feet. I mean, this guy's not a serial killer, not, Ted Bundy.
You can sit down, Ms. Murdaugh.
It's not Ted Bundy.
But he was accused of stealing his wife and son, and Judge Newman allowed him to come unshackled in his street clothes every hearing we had.
All right, Mr. Waters, I did read your response, but I'll be happy to hear anything and I'll take it under advisement.
Well, again, they withdrawn the motion, and now they.
Now they,
This goes back to, it's not the state's fault. He's an inmate serving a 27-year sentence, okay? This is, again, SCDC's policy for a non-jury court. It's going to be dressed out in restraints. He not only faces 27 years, but an additional 40 years in federal court, and he's also indicted for a double murder. So this is a basic security consideration. Again, the intent is not to prejudice anyone. The intent is the security of every time someone is transported out of court. It is a security risk. And the first two goals in any escape attempt is to put someone restrained and in civilian clothes. So I'm here to represent what is basic policy and procedure for inmates serving long felonious sentences with SCDC. I completely understand that we have a jury, the calculations are different, and that is going to be a different thing to do. The remedy for all of that ultimately is the 4-hour process. It's going to be jury selection, and it's going to be instruction from the court, which the jurors will follow, which I know our citizens can.
okay, thank you. All right, I'll take it under advisement and I'll issue an order on that. Let me move on to the DNA. Again,
This judge strikes me as very no nonsense and no bullshit. Like, are you doing it? Are you not? What do you want? Oh, I called the warden myself. Like, she's not taking any crap from either side, which I can appreciate because I am so glad I don't live in South Carolina. Thank God I don't live in South Carolina. Thank God.
I just received the state's response yesterday at 5 p.m. I read it, and I'm going to save it for the next pre-trial because this is what I want to know. I'd like to know how long, Mr. Griffin, it's going to take to analyze exactly what it is you're asking for. And I believe it's genetic.
Yes, Your Honor. And the state's response says, give us somebody to talk to at the lab.
Okay.
So
And
that was conveyed to them this morning. The CEO of Othram's name, email, and telephone number. They have received a VP of Law Enforcement Division at Othram, his cell phone number, and the client intake person that we use now, that I've been interfacing with. And they will be better able to answer specifically how long it will take. We've agreed to pay for it. And just background information.
I'm going to let you pay for it.
These murders happen.
Okay, the judge has a sense of humor too. Like at least everybody like can agree that let's not be uber serious. And but Malin, I just have to address your comment because I agree some things might be better over there than over here. However, you were in Nick Staro's stream last Friday when he was talking about calling a government employee anything and you could be arrested. I can call a government employee or a cop anything I damn well please, and there's not shit they can fucking do about it. And I kind of like that. So, yes, we have our faults. However, there are certain things that I much prefer about being over here. But I still love you, though. Still love you.
Happened in 2021. We're in 2026. 2021, there's no such thing as artificial intelligence. In 2021, this genetic genealogy was just on the ground floor. In 2026, we are light years ahead. And so what we're asking for didn't really exist in 2021. It does exist today, and Othram is the leading lab that performs this analysis. They did last year, in 2024, the statistics are that they cleared 200 cold cases on behalf of law enforcement around the United States and the country. They work with law enforcement every day. The most high-profile case they did was at the University of Idaho, the Moscow, Idaho murders that took place about the first week of our trial. College kids were massacred in a house at the University of Idaho. They had a DNA sample they ran through CODIS. Came up nothing. There was nothing. The state of Idaho Police Department, like SLED, had a contract with Othram. They sent the test Othram. Othram does this genetic genealogy DNA analysis, and it comes back to a family member who'd done a DNA test, ancestry test, of the person who committed these murders, Brian Koberg. That's how they solved the Moscow murder cases, was through Othram lab. The difference between, and they say they don't have enough samples.
And for those of you who are living under a rock, the Moscow, Idaho murders is Brian Koberger. So, just in case y'all didn't know. And yeah, Malin, right? I don't call cops cocksuckers. There was only one or two or whatever. That's what they couldn't prove. So,
samples to get through CODIS, and I've talked to the lab about that, and that's not an issue. CODIS uses an analysis called STR. This analysis is SNP, and they call it SNPs. CODIS has 20 data points. SNPs has 500,000 data points that they analyze. Now, it takes a while to do that, and so, we're going to have to see what the lab says. They've asked me to get information from SLED as to, they'd like to see the electropherogram or mixture proportions so they can have a better handle on it. And I'd ask Mr. Waters to give us a name so that these experts can interface. But what they're doing in Houston, Texas, they don't do in South Carolina at the SLED lab. There are handfuls of labs around.
I'm sure they don't do a lot of shit at the SLED lab that they do in other places of the country. I'm just spitballing here, but something tells me that there's a lot of technology elsewhere that's not in South Carolina. Just a thought.
Country, and they are they're certified. They work with law enforcement. I don't know that they work specifically with SLED. They're familiar with SLED, when I spoke with them, but they have a whole division.
So you need an expert's name or whoever has this sample to see if there's a viable sample that you can send, that they
Correct.
could send.
And they can work with the extract that SLED used when they did their STR analysis. They
Okay.
can work with that out there. They told me, but
Mr. Waters, can you give him a name so he can move forward?
That's what I put in my motion, Your Honor, is please give us a name, and I'm happy to have SLED reach out and talk to them about what their supposed capabilities and proposals are and any procedures, and I'm then, once they privy to that information, I'm happy to discuss those with the defense. If for whatever reason we can't agree, we'll come back to the That's precisely what I put in my motion is, let's talk to, let the experts talk, so that my experts can hear, what it is that they propose to do, and I'm happy to consider.
and I gave him 3 names and contact information this morning, and I've asked a name that I can send back to my folks. I do want to address this red herring argument. The DNA that we're talking about, Your Honor, came from Maggie Murdaugh's left fingernails. That was tested by SLED with this STR analysis. The DNA sample number 70 that we're asking to be tested, it positively was not Alex Murdaugh's. Any of the other folks who they took buccal swabs from went through a long list, not them, except for one potential, and that potential, the ultimate result was it's 11 times more an unknown male, so they know it's a male, than it was this person. That's how they do things in their DNA analysis. And Mr. Waters said, well, there's no evidence of struggle, but there was a shell casing under Maggie Murdaugh's body from the gun that killed her. I mean, that shell casing and that gun had to be in very close proximity. Maggie Murdaugh's cell phone was missing from the crime scene. Was DNA transferred at that point in time? And so we don't think it's a red herring. We think it's very important. Now, it may turn out to be, innocuous. We don't know, but it's worth looking into.
Okay,
And this is the SLED seem to have gone to the Canton, Massachusetts School of Forensic Science, because even if you think Alex Murdaugh is guilty of everything, ethically, you need to investigate everything. And if there's a shell casing underneath her body and you didn't test it for anything, if her cell phone is missing and you didn't bother to figure out where the hell it is, there's just certain parts of this investigation that are like, is this Massachusetts and y'all didn't tell us? Did y'all go to the Canton School of How to Police? It's just, which lady? This one?
said no.
This one right here? An aggressive mannequin?
This is what I do want you to do, though, Mr. Griffin. I want to know how long it's going to take to analyze what it is that you're asking for. And even if I expedite it, I'd like to know how long it's going to take. And I'd also like to know if there's even a viable sample that they can get. And we will discuss this at our next pretrial. Anything?
Well, and that's the thing. They don't know until they fucking give it to someone who knows more than them. See, there's a reason that I like these lawyers, is because they are like, here's what we think is a good idea to test. However, that is not my job. That is people who are smarter than me. I'm going to give the information to people who are smarter than me and let them figure it out. They don't try to act like James Owens or Luthman or Bubbles, who think, or flip loose lips, who thinks just because they are trained in law that they are rocket scientists or brain surgeons. You have to have a brain to be a brain surgeon. Just a thought. I have thoughts. Hey, there's a shit ton of, this is what made me not like the state, is they did what Massachusetts did, and they just went, it's the significant other. Let's pin it on the dude. Let's pin it on the girl. And that is not to say that it is not him. But they got so hyper focused on it being Alex Murdaugh that they ignored any other possibility. And that's what I can't stand about investigations. like I jump on high horses, but I'm like, welcome to my TED Talk. This is what I hate about investigations. When you get so hyper focused on one person being the problem that you ignore everything else that might actually be the problem.
Mr. Waters, you're going to give them the name of the person that SLED that he can get in contact with. Let's see if there's a viable.
No, I'm just a bitch.
No, I'm a
Did y'all catch that?
bitch.
Did y'all catch that? And Volusia won. Thank you for the birthday gifts. Did you say thank you for the birthday gifts? I am just. I can't say that I'm not playing nice anymore, but I'm not filtering shit anymore.
And no more.
And neither is she. Yeah, Creighton Waters is like, he has a very punchable face. Yeah.
Yeah,
You heard that?
I had that.
Yeah, I'm just a B word and don't repeat.
Wow.
Oh, yeah. Wow.
Sample.
And the lab has told me if there's not a viable sample, we'll tell you that. But they work with a lot less than.
Okay. Well, let's start with that. Let's make sure we get a viable sample, and then we'll go forward. And we're going to go forward at the next pretrial. I promise you, the pretrial is not going to be that far away. All right. Let me move on to the motion for change of venue. The defense filed a.
Heidel, every time she sees you, you type, she goes, Birdie text. Birdie text. Angel,
Yeah.
who's that?
Booty tax. Booty tax.
Birdie text.
Booty tax.
Yeah, she said shit, and she also said
Booty
bitch.
tax again.
Birdie text again. Yes.
Change of venue motion. The state has not had the opportunity to answer yet. So I'm going to give them time. In the meantime, before our next pretrial, if at all possible, if y'all agree on a change of venue, please give me some suggestions if y'all can agree on it. If you can't, make your own suggestions, and then I will decide for you if we go that route.
He didn't decide if the afternoon here today. And they were able to talk to each other, and we have already talked about this. I think we'll have continuing discussions, depending on who you set your next pretrial.
An answer for me?
Try, if I don't have to keep driving down.
Yes, Your Honor. Of course, without taking a specific position right now, I
Right.
start feeling this morning that we can kick some things around, and like you just said, if we agree, great. If we don't, then we'll work it aside.
That's right. Don't have a problem with that. Okay, perfect. All right, now let me address, I see Mr. McCullough sitting out there, and then I also have another, they're both the same protective order, but they're wanting two different things.
Ours is not the same as
That's right, they're two different things. Right. As far as, but I think before we go there, Mr. Harpootlian, I believe, Mr. Waters, am I correct in stating that you're working on a response to both of these? There might be some redactions that you wanted, and you're going to submit that to the court? Okay, and I'll be able to address that at the next pretrial conference.
Yeah, we are generally in favor of those being unsealed, but they will have to be done judiciously and with appropriate redactions to preserve their identities.
Right, because I did receive something from SLED, an email from SLED.
General Counsel Adam Whitsley was present here today and selected.
Where is he? Okay, I did receive your email, and just get me an answer on that, and we'll decide at the next pretrial then. Okay, those were all my bullet points. So let me ask the lawyers, did I miss something? Is there something you would like to add?
One thing Your Honor had mentioned is the location of pretrial hearings. And from the state's perspective, we're happy to come wherever Your Honor happens to be for the purpose.
Okay.
And we're more than happy to come wherever you are, although this production of these hearings might not dictate. We certainly suggest you come to a venue like Washington County, where there's plenty of room and an extraordinary accommodation.
I think they've done a really good job with security and with the press and being organized. And this is my home county. Let me just ask and throw this out there. Mr. Waters, is there any objection if we hold pretrial here? The reason being we have a big courtroom. I already have security set in place. I think the clerks and both clerks and security have done a really good job. This is not the only courtroom in this courthouse, so I won't disrupt holding court in Lexington, which I would not want to do to any county. Sometimes I go to really small counties, and I don't think it would be good to hold a pretrial there. Does it suit?
From the state's perspective, again, being a longtime AG, I've been in pretty much all of them. And as an AG, Lexington is like a second home, obviously.
Convenient.
Solicitors, office, law enforcement, the court, of course, is very accommodating here. So this is certainly, I think, would be of most convenience for parties as we get ready for the process.
Okay, it's not far for anybody to travel, Mr. Harpootlian? Okay, then I will try to make sure that when we arrange these pretrials that we will try to be here in Lexington. Anything else, Mr. Waters? Defense?
That's all we have, but if we could talk about that schedule for the next pretrial.
Oh, I'm getting ready for it right now. Let me tell you what I have. I've gone through my calendar. And so it's hard to get lawyers together, especially when I have this many lawyers. So let me throw some dates out to you. August the 13th and the 14th. July 29th, the 30th, or the 31st.
So, in chronological order, the first would be
July 29th.
I'm scheduled to be out of state with that from the 29th through the 31st.
Okay, then let me move on to August 13th.
Okay, she's being extremely loud, but one of the things that I did was I looked up Lexington, South Carolina. It looks like a suburb of Columbia. It's over 2 hours from here. Looks like I'm not going anywhere near that courthouse. Whereas Colleton County was like an hour and 15 minutes. And on the way to Charleston, like halfway between my house and Charleston. So, but she's what does that say? What does that say?
Nah.
What does she say?
Cupcake.
So, Jeffrey, she can't say pecuniary advantage yet, but she can say cupcake.
And 14th.
We have a mediation on the 13th. The 14th is available.
And I'm going to skip them talking about dates because it's not important.
August the 14th it is. That will be our next pretrial.
August 14th.
Now, with that said, I'd like to have all motions by August the 7th, if I could. I like to read my motions. I like to be prepared.
I like this. Y'all, our hearing is August 14th. Please have your motions in by August 7th so I can actually read the shit you send me, not have a response by 5 o'clock the night before our hearing. I like to read the shit you send me so I can comment on it and rule on it maybe like appropriately.
So if I could have your motions, I understand that some of them are late. You might think of something at the last minute. That's fine. But please don't file something at 10 o'clock at night and expect me to rule on it in the morning. Okay?
I apologize for those coming in late.
No, you're fine.
To the office just to make sure we had something out.
Take your freaking hand out of your pocket.
Mr. Waters, you're fine. I was not planning on ruling on those motions. Now, had I been, I might say something different. But please don't do that to me, okay? Now, let's talk about a trial date. The only other information I would like to know is how long this DNA is going to take. I would like to know that, but I'm going to tell y'all, I'm thinking April the 5th. And this being, I'm trying to get through Easter, and I know how hard it is to pick a jury when you've got spring break. That's usually right before Easter. It is the March. Is it the 28th? I think it's just the week. It's March 28th. So I'm thinking April 5th. I know that we'll have a new attorney general coming in. Mr. Harpootlian has already told me it's going to take 6 months to get experts prepared and ready to go. That would give the new attorney general time to look at his case in case he's going to be here and join us. And let me tell you this, tell both of y'all, I think y'all know me pretty well. When I set a trial date, I don't do continuances.
So she just made that statement. So I just have to make a comment on that statement, because if you watched the Carly Gregg trial or the Carly Gregg Supreme Court appeals hearing or oral arguments, that was one of the problems that the defense had, is the judge said that they don't do continuances. And that was their grounds for an appeal. So I am just I don't disagree. I don't agree with the Carly Gregg defense bringing that up, because they never actually asked for a continuance. However, this just proves that Judge Arthur in Mississippi is not the only judge who says, "I don't grant continuances. Get your shit together."
I don't do it. That'd be a really good reason. So, how does April the 5th sound, Mr. Waters?
Yes, ma'am. We'll be ready.
Mr. Harpootlian?
We'll be ready with some contingencies if the DNA takes longer, for instance, or
I will have that information by next pretrial. If I need to extend it out a couple of weeks, I will, if that's the case. Please do not think that this case is going to be tried a year later, because it's not. We're going forward.
more than happy with that. Mr. Murdaugh is more than happy with that. I just, again, everything like, because the science in all these areas is much better than it was 5 years ago.
I understand. Technology changes overnight. Overnight, I understand. Mr. Griffin, anything you'd like to add?
Yes, Your Honor. The Supreme Court reversed this case on misconduct by clerk of court, but the Supreme Court also addressed financial crimes evidence, and depending on how much of that or any of that comes in, will determine the length of the trial in many respects. Judge Newman last time would not rule pretrial on that issue, and it is going to be an issue that we're going to have to brief and argue with Your Honor as to, we don't think any of the financial crime evidence should come in at trial. And so I'm just flagging that it would be helpful to us, I believe, and to know if we're going to have to defend against that during the trial, or are they going to be able to put it up. And so I'm just asking maybe some earlier date where we can have, Your Honor, address those issues.
We will. I'm just going to tell you, I like to address all pretrial matters beforehand, because when I say April the 5th, we're picking a jury and going forward. All those issues should be decided by then.
Your Honor, that's my practice as well. We filed extensive pretrial motions prior to the prior trial, putting all our cards on the table. It's exactly why we thought that was admissible.
Thank you. I appreciate it. Anything further before we adjourn? Mr. Waters? And Mr. Harpootlian?
All right, so they's done. Thank God. Oh, I like this judge. There are some things that I think are really interesting that she said that I've seen defense attorneys have problems with out of other judges. However, I think she addressed it in a way that is like, hey, if there's something that actually comes up that this case needs to be continued for, I get it. I will grant that, but I'm just not going to grant a continuance because you didn't sleep well last night. Angel, you got to get down. Then you got to shh. Because mommy got to talk now. And Janet, thank you for the $10 super chat. Happy birthday month, baby squid. It's my birthday month too.
Happy birthday, Mama.
Happy birthday month.
Happy birthday, Mom.
It's not my birthday.
Happy birthday, Mom.
All right, so we are going to get Angel, you got to get down. Then you got to be quiet. I have no problem with you being up here. Everybody likes it, but it makes it really hard to pay attention and read and do two things at once when you are screaming.
Stop.
Alrighty.
Stop. Stop.
Ma'am.
Stop touching.
All right. So, this is the defendant's motion to dismiss. So, this is the federal case where Alex Murdaugh sued and is currently suing Becky Hill, the former disgraced clerk of courts for Colleton County. And we are going to kind of skip through this kind of quick because some of the things that she basically addresses were covered in the court hearing. So, respectfully moves this court to dismiss plaintiff's complaint for failure to state a claim and for court's lack of subject matter jurisdiction pursuant to 12b-6 and 12b-1 of Federal Rules of Civil Procedure. Plaintiff's failure to state a claim for relief. Plaintiff alleges, in short, defendant's actions deprived him of an impartial jury. That's what the South Carolina Supreme Court said. And that he is therefore entitled to recover the full sum of the money spent for his criminal trial defense. Such damages fall outside the scope of 1983 and 1988. The Fourth Circuit has never established that damages stemming from the legal costs associated with defending an underlying criminal case are redressable under the statute. So, similarly, and for the same reason, defendant is entitled to dismissal of plaintiff's claims pursuant to Rule 12b-1, where compensatory damages sought by the plaintiff are not traceable to the defendant's actions. Finally, to the extent that if plaintiff argues otherwise inconsistent with his complaint, he seeks damages related to the second future trial. Defendant likewise moves to dismiss plaintiff's complaint under 12b-1. Under such a theory, plaintiff's damages have not, and indeed might not ever accrue, and plaintiff's suit would therefore not be ripe for adjudication, divesting this court of jurisdiction to entertain the same. It's just, and then here's the part where I just get like, my blood pressure boils, because I don't like Becky Hill. I don't like Alex Murdaugh either, but I don't like Becky Hill. So this is I don't like anybody. Everybody sucks for different ways. Finally, and most critically, defendant is entitled nonetheless to 11th Amendment immunity, quasi-judicial immunity, and qualified immunity. I freaking hate immunity. Hey, Celestia. How are you? So, Charles Turner, that is Becky Hill attorney, and memorandum in support. Oh, I just, so he repeats basically the same things that he already said. Standard of review, bunch of case law, and I don't have access to Westlaw, so I don't know if any of this case law is actually good or not. I have to take their word for it. However, Ashcroft v. Iqbal, if I haven't said that 10,000 times in the last year, a claim is facially plausible when the factual content allows the court to reasonably infer that defendant is liable for the misconduct alleged. When considering a motion to dismiss, the court must accept as true all of the factual allegations contained in the complaint. The court may also consider documents attached to the complaint, as well as those attached to the motion to dismiss, as long as they are integral to the complaint and authentic. So, we're skipping through this because it's 46 pages, and y'all, we don't have the mental bandwidth to listen to 46 pages of Becky Hill's whining lawyer. Plaintiff alleges that during the course of his criminal trial for the murders of his wife and son, which began January 23rd, 2023. Okay, so it was 2023. I forget. 2022, 23, and 24 all kind of run together for me. And ended March 2nd, defendant Becky Hill had multiple improper contacts with and made multiple improper prejudicial comments to the jury. that has also been backed up by the South Carolina Supreme Court, and also the fact that you don't have a job anymore. Just the South Carolina Supreme Court set aside plaintiffs' convictions and ordered a new trial upon finding defendants' actions were improper and presumptively prejudicial. Plaintiff brings the instant civil suit under 42 U.S. Code 1983, seeking to recover compensatory damages for defendants' alleged constitutional violation of Murdaugh's Sixth Amendment right to a fair trial by an impartial jury. I mean, y'all, what happened? It was like a time warp. Little human. I hear, yeah, I just like 16, 17, and 18 to me all run together. It's weird. Certain years all run together. Plaintiff's legal defense team, a combination of attorneys from Griffin Humphreys, LLC, and Richard Harpootlian. Sorry, Dick Harpootlian just makes me like giggle every time I say it. I will never not laugh at the name Dick Harpootlian. It reminds me of something that should be in Jaws. I don't know why, but it does. For their work on his underlying state criminal trial. So she goes into the foundational principles of 1983. Remedial provisions bar plaintiff's recovery of legal defense fees incurred in connection with his underlying state criminal trial. Plaintiff's suit is based on novel theory of liability and recovery. To the undersigned counsel's knowledge, this case is a first impression. No federal circuit or district court has addressed the question whether a criminal defendant who alleges their Sixth Amendment right to an impartial jury has been violated can recover damages for the legal defense fees incurred with the connection with the underlying state criminal proceeding and in a subsequent civil suit. Well, here's the thing. So I can understand that in a normal sense of the word. Like if say your appeal got overturned because of the judge making a wrong decision, totally can see and understand that has never been brought before. However, this is a special circumstance. I don't know, or I've never heard of a case where a clerk of court has caused a civil rights violation and that has been backed up by the Supreme Court of that state.
Mommy, I want
As according to the South Carolina Supreme Court, Becky Hill put her finger on the scales of justice. So it's it's y'all, I don't. So yeah, I can agree with the undersigned that this is new. However, I believe that the actions of his client are virtually unprecedented. I you know, you're gonna spill that all over yourself. Even expanding this inquiry beyond the narrow scope of the Sixth Amendment, the Fourth Circuit has never directly addressed whether 1983 plaintiff can recover attorney's fees in connection with an underlying state criminal proceeding. They've probably never dealt with a clerk of court interfering with a jury. I'm just, on top of it, in order to sell books and line her own pockets and become rich off the backs of a murder trial. The optics here, Becky Hill, not like you will ever see this, but just in case, if you ever see this, you're a bitch. What you did, I don't like Alex Murdaugh, but you know what? You're worse. You're worse. because what you did, who knows how many other trials that you interfered with because you didn't like the defendant. Every case that you had any involvement in should be looked at. You are the proctor. You are the trooper proctor of the South. Congratulations, lady. And Harry, thanks for the $5 super chat. What was that name again? Dick Harpootlian? Richard Harpootlian. So the general purpose under damages under 1983 is to compensate persons for injuries that are caused by deprivation of constitutional rights. And a clerk of court interfering with a jury trial, you don't think is interfering with his right to an impartial trial by a jury of his peers? The mental gymnastics that lawyers do, like, some of y'all need some, like, some of y'all are Simone Biles, man. The flexibility that you have to do for this level of mental gymnastics. Yeah. Emphasis that added damages awarded under 1983 should be governed by the principles of compensation. But there is the question that I have is, even if he wins this, he can't recover any actual damages, possibly because he's a prisoner. You know, I'm from the North. I enunciate. You know, it's just federal circuits are split as to whether 1983 permits recovery of legal fees incurred during underlying state criminal proceedings. See, and this, I wouldn't, like I said, I'm not a lawyer. Y'all can take this one with a grain of salt, but I wouldn't put shit in legal documents that aren't 100% on my side. And federal circuit courts are split as to whether 1983 permits recovery of legal fees. I don't know if I would put that they're split. Like, I just don't know if I'd argue that. Like, I don't know. Hey, Ulrich, how are you? Yeah. So your comment makes me laugh. Cart put Lee in is like cart before the horse. Never mind. So I got an email this morning, and the first thing was like, somebody said, don't put the cart before the horse. And I say that all the time. And I messaged the person back, and I was like, I didn't even get through the email completely because the second sentence made me laugh, and I had to message you because, well, like, I say that all the time, especially when Spawn Trooper's on. I'm like, can we not get ahead of ourselves and put the cart before the horse? Well, his family could collect the damages. Then I remembered why that was a dumb thought. Well, he's got one son left. So, yeah, that too. He owes a crap ton of money. The lawyers were paid out of the money they can't touch for legal recovery, but if repaid for that, it wouldn't go back there. Yeah, hey, Tammy, I hope everything is doing okay today. Hugs to you. And if you are the praying type, our good friend Tammy here and the mod, one of my super mods on my other channel, could really use our thoughts and prayers right now. So, the Second Circuit likewise found that plaintiff's incarceration was not proximately caused by the alleged Fourth Amendment violation. The panel determined that unconstitutional seizure in search of Towns' person, I feel like they've used this all the time, was not a proximate cause of his conviction. I'm with the more documents I read, it's like, I don't know the case law and the full case, but they use, lawyers tend to use the same cases over and over again for things. No judgment. I'm just, like I said, not a lawyer, but when you can pick out a case and you're like, oh, Ashcroft v. Iqbal, I've read that like 1,000 times. You know? Sweet. I love to hear that. It's just thereafter the panel discussed a second independent reason for which the plaintiff was foreclosed from recovery of compensable damages was improper, where the injury plaintiff pleads does not fit the damages he seeks. It's I am skipping through this, but we just watched an hour of a hearing, so we're hitting the highlights. This court should adopt the Second Circuit's rationale barring recovery of legal fees incurred during an underlying state criminal proceeding. Towns is the proper persuasive authority for this court's determination of the issues. Defendant submits that Third and Seventh Circuit adopted Towns as opposed to Barunda because the Ninth Circuit's decision improperly omits any discussion of the Supreme Court's tailoring instruction. The goal of the court's 1983 jurisprudence has been to tailor liability to fit the interested protected by the particular constitutional right in question. Explaining case law makes clear we should keep in mind that interest protected by the constitutional provision and should weigh the competing policies in designing remedies for Fourth Amendment violations. And this all sounds great, but I keep going back to the fact that this is an unprecedented situation. Possibly. Like I said, I don't know if I haven't been able to find other cases where clerk of courts have interfered with juries quite like this. I haven't been able to find it, but that's not to say it hasn't happened. However, could this be new case law? Potentially. Like Becky's hair, only the highlights. Yeah, kind of like mine. Yes, false prevention is so important. And that's a lesson in like med management and overall health that can lead to falls, not necessarily bad balance. So, defendant urges this court to adopt the rationale set forth in Towns when analyzing the two dispositive questions before it. One, whether defendant's alleged constitutional violation caused the attorney's fees incurred by the plaintiff in connection with his underlying criminal trial. I don't believe that because he was already on trial, so I'll give you that one. Whether awarding damages to compensate plaintiff for the cost of defending the underlying criminal trial would be tailored to the interest protected by the Sixth Amendment right to an impartial jury. I think the fact, okay, like I said, not a lawyer, never claimed to be one. However, and this is where common sense and the law don't always get along, but my common sense would kind of tell me that if the state of South Carolina decided not to retry this case, that he wouldn't have a leg to stand on because he was already on trial for murder before she interfered with the jury. However, the fact that he is on trial again and is going to have to pay more legal fees, maybe this can create a new case law, or there is case law out there that I don't know about, which is completely plausible because not a lawyer. However, the fact that he has to pay for his lawyers for another trial, because they aren't doing this shit for free, I think is an important piece to this puzzle. Like I said, could be wrong. That's just my common sense take, but we all know common sense and the law don't always get along and don't always match. I don't know why Squidlet got to be so adorable, but she is so adorable, makes you want to have more babies. I am Mr. Squid is one and done, and I'm 40 years old. I'm not doing the infant thing over 40. My body already hates me. There's no okay, I have to read this slowly because I wanted to insert a giant eye roll. There's no causal connection between defendant's alleged constitutional violation and the attorney's fees incurred by the plaintiff as an underlying criminal trial. Not for the first trial, however, the fact that it was overturned specifically because Becky Hill put her fingers on the scales of justice, as the South Carolina Supreme Court said. Those are not my words. That's the Supreme Court's words. He is having to incur a new set of attorney's fees. So while I half agree, you know,
Bye.
So-
Bye. Mommy, bye.
yeah.
Mommy, bye bye.
Mm-hmm.
Bye bye.
Not yet.
Bye bye, dudes.
Not yet.
Bye bye.
Plaintiff cannot recover compensable damages here because
Bye-bye.
the injury he pleads does not fit the
Bye-bye,
damages he
Mama.
seeks.
Bye bye, Mama.
I,
Mama, bye bye.
in a way, I kind of agree with that because he was already on trial. However, because the state is retrying the case,
Stop.
I think there should be a amended complaint to this. I think there should be an amended complaint because I think they have a case. I just don't know if it's. I think this is a loophole. Well, you were already on trial for murder, so me interfering with the jury didn't cost you anything extra. Maybe not now, but future damages, because I have to pay for another round of attorney's fees for pretrial hearings, motions, and a new trial. So I kind of agree with some of the things that are said in this motion, but only on a technicality. Yeah, not eat time, Squidlet. Nice try.
Nobody.
What if he's found not guilty? Does she actually get credit for getting him a new trial he might otherwise not have had? Well, if she wouldn't have interfered, they might have found him not guilty on the first try. We don't know. And honestly, I don't think that I don't think that
Hey, this don't me.
I
Don't
don't
do me.
Here you go.
Don't do me.
I don't know if the state put on a great case last time. So she might have done the state a favor too. A damages award compensating plaintiff for the cost of his underlying criminal trial would not be tailored to the interests protected by the Sixth Amendment right to an impartial jury. And I think this is where she goes into the fact that so if you're found to have an impartial or a jury tampered with, you're fixed to that, and your compensation for that is a new trial. So don't get mad at me. Don't blame me, and I'm not going to compensate you because your compensation is a new trial. It's a it's a big, yeah. The Constitution entitles a criminal defendant to a fair trial, not a perfect one. Yeah, but you interfered with that. Like you interfered with that. So due process does not require a new trial every time a juror has been placed in a potentially compromising situation. Were that the rule, that few trials would be constitutionally acceptable. Due process means jury capable and willing to decide a case solely on the evidence before it, and a judge ever watchful to prevent the prejudicial occurrences and to determine the effect of such occurrences when they happen. However, like, The harmless error doctrine is calculated to secure the interest of fairness through deterrence of prejudicial conduct by a third party, which threatens the integrity of a jury's fact-finding process and verdict. Where jury partiality is alleged, the Supreme Court has long held the appropriate remedy is a hearing in which the criminal defendant can prove actual bias. In the context of allegations, private communications with the juror during a trial about the matter pending before a jury, this evidentiary hearing is commonly referred to as a Rummer hearing, after the Supreme Court decision in Rummer v. U.S. After a hearing to determine the circumstances, the impact thereof upon the juror, and whether or not it was prejudicial, the court may grant a new trial. So, accordingly, the Sixth Amendment is not automatically violated when there has been constitutional error. It's just... it's so like, it's fucking shitty. It's so shitty. It just goes into plaintiff cannot recover damage for the legal defense fees. And this is another aspect of their... I heard Larry say it, and I'm paraphrasing. When you don't have a case on the merits, you attack the case law and the I can't remember exactly how he phrased it. You attack the process because you don't have the merits. That's when you get technical and you get, well, this process is wrong or this loophole. That's when the lawyer finds all these legal loopholes to jump through and technicalities because you don't have the merit to back up your case. And I think he mentioned it. If you haven't checked out Larry Foreman's last video on Karen Reed, that he was talking about Mark Diller and Mark Diller's support or having to defend the O'Keeffes in a case that has no merit. And that might be emotionally and mentally taxing. And when you don't have the merits, you attack the you attack the case law and the I can't think of the word right now, but so go check out his last video because that's where it was mentioned, and he brought up a really good point. It's like when you don't have the merits, you attack everything else. And that's what I feel like is happening here. Plaintiff's claim for compensatory damages must be dismissed for lack of subject matter jurisdiction. Oh, if I have to hear subject matter jurisdiction one more time. All good. Yeah. What can I say except you're welcome? All good in the fact that Becky gets to sit comfy in her house and sip a mug of tea in her retirement. Just really annoying and embarrassing for South Carolina. Yeah. Yeah, if you don't have the facts, pound the law. If you don't have the law, pound the facts. If you have neither, pound the podium. Yeah. Something close to that. I can't remember what it was. I listened to the video while I was working, so trying to do, manual labor while listening to stuff, not everything sinks in. Plaintiff cannot establish his claims. Claimed injuries are fairly traceable to defendant's conduct. This is one that I'm going to have to read because I just don't get. Because the Supreme Court, in their decision, mentioned Becky Hill by name. And I'm sorry, like, if someone mentions you by name in a motion or a decision or an order, it's probably not a great thing. For an injury to be traceable, there must be a causal connection between the injury and the conduct complained of. You mean the fact that you interfered with the jury and he got his conviction overturned because of your jury tampering? I mean, there's a big ass causal connection there. The question before this court is whether plaintiff can demonstrate that the extended expenditures for legal representation during the murder trial are attributable to defense alleged violations of plaintiff's constitutional right to trial before an impartial jury. He's once he's once again attacking you were already on trial for murder before I interfered with the jury, so that's not my problem. Yeah, attacking the process while ignoring the underlying principles describes the scenario where an individual tries to undermine the system of justice. Oh, the game's being played. And April can probably either disagree or agree with me, but a lot of lawyering is gamesmanship. Who's got the better game? I think defendant submits that plaintiff cannot. Plaintiff states he spent the entire $600,000 on his trial defense. Plaintiff's complaint omits any detail outlining when the withdrawal was made or when he began paying his attorneys. I'm pretty sure part of that $600,000 also is part of his appeal efforts, which is also interesting in the fact if you break it down and you get like a line by line bill, would she be liable for his appeal considering the reason that the reason he had a large grounds for appeal is because of her. So there's also that technicality too.
Mommy.
This raises a lot of questions for me that I just don't have the answers to because I'm not a lawyer.
Mommy, bye-bye.
We're not going bye-bye yet. We got about 10 minutes left. It's just interesting.
Stop.
Apparently, I'm done talking for the day.
Stop touching it. Oh, sorry.
Too many here passing the phone around.
Stop touching it. I saw you. Mommy will touch it. Mommy, stop. Stop.
Okay.
Stop. I saw you. Mommy will touch it. No. Bye. Bye.
We're not going bye-bye yet. You can go bye-bye.
No, bye-bye, Mama. Bye, Mommy, bye-bye.
The little has spoken, yes. It would be a court, yeah, it would be court costs. So I'd say, yeah, it's just one of those technicalities that I honestly don't have I can infer and I can guess and I can use common sense, but once again, it's, and these are my blue light glasses, y'all. These are not prescription glasses, so when she puts them on, it's
you. Happy birthday,
Yeah.
Mama. Happy birthday, Daddy.
yeah, it all depends on what the.
Happy Daddy. Happy birthday, Daddy.
Are you done?
Yeah.
Taking plaintiff's allegation is true. 9 jurors heard none of the defendant's impermissible statements and based their opinions solely on the evidence before them. The Supreme Court of South Carolina did not agree with you, chick. While undersigned counsel submits it's safe to assume that the work with plaintiff's defense lawyers were being paid began well before the January 23rd, 2023 trial date. For the purposes of this motion to dismiss, defendant assumes arguendo. The date of the first payment was January 23rd. Process had not yet developed. Defendant will, of course, update the accuracy of these calculations upon plaintiff's provisions of evidence demonstrating the date which upon payment began, the total amount of fees received, and the itemized costs for which the funds accounted for. Yep. She's gonna yeet us. We can take a break. I deal with finance and economics. Me with legal stuff is dangerous. I deal with anatomy and physiology.
No, stop. I tell you, Mommy will talk.
I know how to.
Hey, stop touching.
Yeah, I probably shouldn't say that on the stream anyway.
Stop. Tell you, Mommy will talk. Stop. Mommy will talk. Tell you why.
Can I talk, please?
No. Bye-bye.
The doctrine of ripeness bars present resolution of any potential claims for compensatory damages resulting from defendant's alleged constitutional violations.
Tell you, Mommy will talk. I tell you, Mommy talking. Hey. I
think we're done for the day. We might have to finish going through this on another time, But it just goes more into this and then, or the process and pounding the ground, not the actual merits of what she did or didn't do. But she mentions 11th Amendment immunity and qualified immunity, which I hate because she was clerk of court. She was elected. Similarly, defendants entitled to quasi-judicial immunity where the actions complained of by the plaintiff were judicial in nature and related directly to the defendant's judicial responsibilities. Writing a book does not... this is where you want to beat your head into a wall and like be like, people cannot really be this stupid, right? Like this lawyer cannot actually believe the words he is writing. This right here is just bullshit. Sorry. Qualified immunity where it's not clearly established at the time of the alleged constitutional violations that the defendant's actions violated the plaintiff's rights. You didn't know that talking to the jury about his guilt or innocence is wrong and violates his right to an impartial jury?
Stop touching.
I'm so confused. I'm so confused.
No.
It's okay.
Bye-bye.
I have my hands full
Mommy,
every time.
Bye-bye, pet.
Yeah. We're going to go bye-bye soon.
Bye-bye, bye-bye. Bye-bye soon. And bye every day.
Yeah, we're going to go bye-bye soon. It's just one of those things of like, how can anybody be this ridiculous? Could you believe this?
No.
You don't believe this either? I don't either. Do you want to read this? Okay. The South Carolina Supreme Court reversed the decision, acknowledging throughout its opinion the difficulty, the complexity, and conflicting jurisprudence, the Sixth Amendment inquiry, the volatile nature of defendant's conduct that was neither readily apparent nor obvious to the former Chief Justice nor to the South Carolina Supreme Court. That's not what I read. That's not what I read. I read that decision. It's in my Alex Murdaugh playlist. That's not how I interpreted that document. It's not. It's
No
not.
birdie.
No birdie?
No birdie.
Squidlet is innocent until proven guilty. I have seen nothing. Oh. So silly. So silly. Defendant is entitled to immunity. Again, you don't have the merit to stand for. So we're going to talk about immunity. And we all know that I hate immunity. Oh. Yep. I got. Yep. It's okay.
Abby.
Yep. Go on, girl. Yep. All right. We are going to have to get going because I got to do mama duties. But this is basically just a bunch of BS. They are hiding behind the fact that she has immunity, and more immunity. And nothing in this even says, I didn't interfere with the jury. It's, did I interfere with the jury enough to really make a difference? So on that note, I have to go. I have to clean up the mess that is currently all over my chair and my leg. Mama duties ensue. And I will see you guys on the next one. Join me tomorrow over on ETM. We are talking, we have an interesting conversation about companies and who is slowly removing stuff from their, removing chemicals and artificial dyes from their products without telling us. I will see you guys on the next one and try not